We are so excited that you are all here and ready to talk about AI policies and AI governance, and are we even allowed to put that into ChatGPT, Copilot, or Claude? So today's webinar, we look forward to sharing a whole lot of practical content and takeaways about both AI policies and governance with you. So as you can see from our agenda, we've got a lot to cover. But before we do, a couple of housekeeping notes. The slides and recordings will be available within an hour or two after the session. You should automatically receive them if you're registered, but if for some reason you don't, you can download those from the resource page we'll share at the end of the presentation. And please do use the chat or the Q&A function. We're going to answer all the questions at the end of the presentation. So Mark, I'm going to let you go ahead and introduce yourself.
Great, thanks. Do you want to go ahead and advance the slide? Yeah,
Yeah, sorry about that. I just realized I wasn't advancing the slides.
Hi, everybody. Mark Franco. I'm a partner with the Ramon Law Firm. I've been working with nonprofit tax-exempt associate organizations, including many associations and credentialing organizations since 2003. I advise on a number of outside general legal counsel matters, AI being one of them. And I'm really happy to be able to speak today. I want to thank Kathy Lada and Lada Consulting for co-hosting this session. And I also really want to thank all of you for taking some time out of your valuable day to join us for this discussion.
Thanks, Mark. And I'm Kathy Lada, president of Lada Consulting. I have about 20 years of nonprofit experience, and my firm provides associations and small businesses with marketing, membership, education, and AI services, strategies, and plans, as well as offering fractional chief marketing officer and chief learning officer service. I've earned my certified association executive and certified association AI professional designations. And I would also like to thank Mark for being on this webinar with me and providing some really wonderful content that I think you're going to find eye-opening. So with that, Mark, learning objectives.
Yeah, so we're going to cover a few topics today, but hopefully there's going to be some real takeaways for you as part of the session. Some of the things that we hope that you can find useful and take back to your everyday practices, understanding why governance and AI policies are more important than ever, understanding the differences and distinctions between an open and closed LLM, and we'll get into the definition of that if you're not sure what that is. Really trying to make sure that you know the notions between policy and governance, how to implement those, understanding the core sections of a policy, and then applying member data and safeguards for your specific types of organizations. Our first area that we're going to discuss is why does this matter now? Why are we, again, talking about AI and using AI? And it's, for us, we think there's really there's four concerns that are applicable to the work that you're doing now. There's moving regulations, there's what's called shadow AI, there's hallucinations, and that's been in the news a lot, and then there's potential AI use by your vendors and other third-party stakeholders. Next slide, Kathy. Yeah, so with regards to AI regulation, here in the US, it's not moving as fast as it is in other places of the world. For example, in the EU, they already passed AI regulation in 2024. And what the EU AI Act did, it identified high-risk AI systems, and it allocated liability to providers and deployers of those systems, among other things. Now, in December of 2025, President Trump issued an executive order that attempted to kickstart a uniform approach here in the US for AI, but that just really hasn't turned into anything meaningful. So what's been happening, like in many other industries, is that AI regulation is now being handled on a state-by-state basis. And so since March of 2026, about 1,500 different AI-related bills have been proposed across 45 states. Some of the active areas of legislation include regulating generative AI, how AI is used in hiring and employment, and expanding protections against deepfakes and deepfake use. So the takeaway here is that there's a lot of regulation being discussed right now, and the more that you're prepared to, from a governance and policy perspective, to comply with potential regulation, I think that's going to be useful. Next slide, Kathy. So one of the areas where regulation has progressed much quicker than most is in the area of copyright law. And on LinkedIn, I had a little bit of a cliffhanger, and so we're going to get to those things right away. So the Copyright Office has really covered the areas that AI is hitting right now. It's covered it for quite some time. There was a question when generative AI first became popular about whether that kind of content could be copyrightable. And so the courts started to look back and see what's been said previously about how the Copyright Act applies to parties that are not human parties. So we have this case, Urantia Foundation versus Kristen Mehera. And this was a case where there was an American doctor that had a patient who would talk in his sleep at night. And the communications that he was making while he was sleeping were supposed to be coming from some being that was not the actual patient itself. It may have been an extraterrestrial. It may have been some other type of spiritual being. You can read, if you want to, about those sayings and those teachings. You can read about them in the Urantia Foundation's book. Now, the Urantia Foundation, they compiled all of these sayings into a book, and they published it, and this individual, Kristen Mehera, copied some of the content and republished it. And so the Urantia Foundation sued Miss Mehera for copyright infringement because they claimed to be the copyright owners. However, when the court looked at the factual information, they said, in your own book, you say that these communications are emanating from this individual who's talking on behalf of a spiritual being. And you're simply recording those into a written documentation. So the Copyright Act, it only protects authors. It doesn't protect people that are writing down necessarily the words of somebody else. Section 201A of the Copyright Act says copyright vests in the author or the authors of the work. So the finding in that is that the Copyright Act, it protects authors. It doesn't protect people that are simply recording the words of somebody else. Okay. The next applicable case is this case Naruto versus Slater. So Naruto is a monkey, and Mr. Slater is a wildlife photographer. Mr. Slater happened to put his camera down for a few minutes, and Naruto the monkey picked up the camera and was able to take a few selfies of himself, which were then published in a book by Mr. Slater and his company, who then claimed copyright ownership of those photos. Now, a scientist that works with Naruto, that's connected with PETA, they sued Mr. Naruto, Mr. Slater, claiming that Naruto suffered damages because he didn't get any of the benefit from the copyright of those photos that he took of himself. However, the court, after evaluating all the facts, looked at the statute and the information in the Copyright Act itself and said, look, the way the Copyright Act is written, It uses terms like widow, it uses terms like descendants to indicate that the Copyright Act, it's really tailored towards humans. It's not tailored towards animals. Now, one funny aside is that although the court said Naruto can't have statutory standing to sue under the Copyright Act because it only applies to humans, he could have constitutional standing to sue under another type of law. If you want to sue on behalf of an animal, you're definitely able to do that under federal law. You just simply can't sue under the Copyright Act. So all of this brings us now to today and the question of whether generative AI can actually be a copyright holder. And what the courts have said is that no, generative AI cannot hold copyrights because, again, the Copyright Act requires a human author. Okay. Mr. Thaler, he had used generative AI to create a bunch of designs, which he then submitted to the Copyright Office for registration, and they denied it, saying, look, you've listed the author as this generative AI platform, and that doesn't comply with the Copyright Act. The courts affirmed that's the case. The Copyright Act doesn't apply to anyone else but a human author. Next slide. So this slide here gives you some guidance in terms of where to go to read up on this a little bit, but the basic premise is that copyrights only apply to human output and where the output has sufficient expressive elements. Next slide, Kathy.
Yeah, shadow AI is also a thing that is driving the need for AI policies and AI governance that are sensible and cover all your bases. So shadow AI is essentially when your staff member signs up on their own for an account and uses it for work. And the problem with that is that there's no visibility into it. There's no logging of it. There's no shared rules. And it's fine usually for public information, but not for member data. Organizations are responsible for the output of their AI tools, and you need to be documenting significant use of those. And then a couple other issues here. Mark?
Yeah, one of the really big problems with generative AI is the existence of hallucinations. So in 2023, a research firm called Victara, they published results that showed that generative AI systems, they have hallucination rates that range anywhere from 3% to 20%. And these hallucinations turn into real world problems for organizations. I have a couple of examples here. Air Canada, they had a chat bot that told a passenger that they could get a certain bereavement benefit, which actually wasn't true. The chat bot just made this up. And the courts in Canada held Air Canada responsible for what the chat bot was saying, even though Air Canada not very well tried to argue that they're not responsible for representations made by any of their agents, including chatbots. That clearly wasn't the case with respect to how the tribunal viewed it. And I suspect that's probably similar to how US courts would view that type of circumstance here. Next slide. You've seen this all over the news, but there's many AI hallucinations occurring in legal work. And so far, just in the first quarter of 2026, US courts have imposed about $145,000 in sanctions against lawyers because of AI hallucinations that have been popping up in their work. These hallucinations also create inadvertent issues for organizations in ways that are unexpected. We have this case, Walters versus OpenAI. So Mr. Walters, he and this is a 2026 case. Mr. Walters, he is a nationally prominent radio show host. He, at the time, was a spokesperson for an organization called the Second Amendment Foundation. Now, at the time, the Second Amendment Foundation, they had sued the state of Washington for harassment. And one of the board members happened to be a journalist. For one of the board members for Second Amendment Foundation happened to be a journalist who wanted to write on this issue. So he took a link that Second Amendment Foundation provided to their public complaint. He put that into a generative AI platform, and he asked the platform to summarize the information in the complaint for him. And although the complaint was about harassment by the state of Washington against the Second Amendment Foundation, what the generative AI platform summarized was that the case was about embezzlement. And it named this individual who was the spokesperson, it named Mr. Walters as the potential embezzler, even though he wasn't even in that role that the generative AI platform claimed he would be. Being on the board of directors, the individual passed on this information to Mr. Walters, who then sued OpenAI. Now, OpenAI was held not responsible, but still, they had to go through all of the time and resources to address the complaint. You don't want to be in situations where use of generative AI is leading to these really obscure outcomes for organizations. Next slide. Yes, as we're presuming, AI is already impacting your operations, whether it's hallucinations that are occurring, whether it's the shadow AI that's occurring either by staff use or third-party use or stakeholder use, or whether it's all of these moving regulations that are going to hit at some point, and it's likely sooner rather than later. AI is already impacting the way that you're going to be working, and so it's really good to be proactive instead of reactive at this point. Next slide, Kathy. And as we said, hallucinations, they're not going to be a defense, and you're going to be held liable. You're going to be held liable for them. That's about bottom line. Yeah, so next we're just going to go briefly over what's some of the distinctions between an open and closed LLM. LLM means large language model. It's a term that's used to reference these very public, large AI generative platforms. An open large language model, its characteristics are that it's publicly accessible. There's a collaborative approach, meaning it's learning from lots of different types of resources. It's adaptable to all kinds of different things, and you can usually take it and customize it to whatever you want to use it for. Next slide. So in terms of closed models versus open models, the big difference is that the closed models are usually going to be proprietary and highly restricted in terms of access, and then development in terms of how it's being trained is going to be from very narrowly tailored, monitored resources. Next slide. Yeah. However, when it comes to risk, okay, having a closed system does not necessarily eliminate risk, and there's still plenty of risk whether you're using either an open or a closed system. Some of those risks that are related include privacy, copyright, data breach, attorney-client privilege, hallucinations, and bias. Next slide. Okay, we all know, or you should have learned by now, that entering information into an open LLM is super risky, right? Because an open LLM essentially means that you're providing that information to anybody who may use that LLM, open LLM in the future. Okay, next slide. The problem with even a closed LLM, sorry, can you go back for just a second?
Oh,
The problem
yep.
with just the, yeah, the problem with the closed LLM is that if information gets out, it's really hard now to try and limit the exposure that information may see. Now, I have an article on my bio. I'm happy to provide that to anybody that hasn't seen it yet. But earlier this year, in 2026, the US Supreme Court found that online service providers will no longer be held liable for users' infringement of copyright. That case is called Cox versus Sony. Before Cox versus Sony, if you found that you had content out there that was on Instagram or Facebook or one of these other types of platforms, maybe even ChatGPT or Claude, you could always send what's called a DMCA request to take it down. And the DMCA, it's a law that puts liability on organizations that are hosting infringing content. Now, with this new Supreme Court holding, those organizations don't have any incentive to take your information down because the Supreme Court just held they're no longer going to be held liable for those kinds of actions. So even in a closed system, the only thing protecting the information that you've entered from wide exposure is the security measures of that system, right? And so if you have stuff that's super proprietary, I'm not sure that's a reliance that you would want to make. Okay, next slide. Closed systems also, open and closed systems also don't protect information that you're putting in there from being discoverable because you've exercised your attorney-client privilege. Okay, in a 2026 case, U.S. versus Hepner, an individual who was under investigation for white-collar crime, he was using a generative AI system to help develop what he called a defense strategy. Once he figured out that he was under investigation by the FBI. The FBI raided his residence and they found a whole bunch of chat results from this generative AI system that they took as part of the warrant. He tried to argue that stuff is attorney-client privilege, and the court said that it's not. Because really, attorney-client privilege needs to have certain things. It needs to be a communication with an attorney, and it needs to be confidential, which clearly those two things don't apply with a generative AI platform, even a closed platform. So they found that that information wasn't subject to attorney-client privilege. Next slide. Yeah,
Okay.
he also tried to argue that it's work doctrine, but work doctrine applies to attorneys. That didn't really work for him either.
Thanks, Mark. Now that we've sufficiently been scared about all of the legal sanctions and whatnot, no matter what AI tool you use, your association should have basic protections in place. So now we're going to talk about AI policy and AI governance and why that matters. So starting with some definitions, an AI policy is like a rule book. It's the actual written statements about what people can and can't do with AI. Things like staff may use AI to draft newsletters, but human must review it before it goes out, or we will never put members' private information into a public AI tool. Policy is the what are the rules part. The AI governance is the whole system that makes those rules real and keeps them working. It's the who's in charge and how do we run this part. Governance answers the questions: who decides what the rules are? Who checks that people are actually following the rules? What happens if someone breaks a rule? And how often do we look at the rules and update them as AI changes? Questions like that. This matters for associations because we answer to members and usually a board, so trust is everything. Governance is what lets you honestly tell your members and board, we have real people watching over how we use AI, not just a document that nobody looks at. Rules go stale fast with AI. Governance is the ongoing engine that keeps revisiting the policy so it doesn't fall behind. A policy written today could be outdated in months. Lastly, responsibility needs a name. If an AI tool makes a mistake that affects members, governance systems have already decided who handles it and how. Policy alone does not do that. So your AI policy and AI governance system work together to help you use the AI tools safely, efficiently, and effectively. Going back to our earlier conversation, none of these things are a guarantee, regardless of what type of LLM or tool you're using. Your AI policy also doesn't have to carry every data restriction if your AI governance layer already enforces it. So the gaps are guaranteed between rules and principles. Rules only cover what they list, and any list is a snapshot of yesterday's known risks. The day a new tool shows up or a new data type does, the list has no answer. Governance is the thing that fills that gap in real time. So this is where the nuance problem comes in, and it ties back to the enterprise versus individual LM use distinction earlier. Saying never paste member PII, personally identifiable information into any AI tool is blunt because a rule can't hold the exception. What you actually mean is not into an unapproved tool because your contracted enterprise instance with a no training agreement and of an open source LLM might be perfectly fine for that data.
Yeah, Kathy, can I make one comment on
Sure.
that? So, yeah, I can give a real world example of governance versus policy and the chatbot use. I've seen personally where a chatbot was being used to service an organization's customers that were in the credentialing world, and the chatbot provided an individual with exam result information that it wasn't supposed to. And that was because proper governance measures weren't in place to make sure that the chatbot was only accessing the information that it should be able to access to fulfill that specific customer service role.
Yeah, and that's definitely one of the principles of technical safeguards and clean data that we'll talk about. So there are three types of governance, good AI governance: risk mitigation, technical and tool standards, and clean data. Risk mitigation is about uncovering places where AI use can cause harm to members, the association, the staff, even to society, and developing a plan to deal with those things. The technical safeguards also exist and should be considered part of your AI governance system. And lastly, clean data is a must. So let's talk about risk. The big picture when it comes to AI matters. Ask yourself these types of questions. If you can't answer them, you likely have a governance problem. Some of these answers should be found in your AI policy, others in your governance SOPs. The presentation is too short to go into detail into each one of these concerns, but let's focus on a big one for associations: risk. So I recommend creating a list of potential risks that your association could face in using AI tools, from simple chats to member-facing chatbots, AI agents, and assistants, and then assessing the likelihood of those events occurring. Here, I divided up the lists and the risk types into 5 types just to make it easier to address them and just to comprehend all the different sources and types of risk. So technical, operations, strategy, brand reputation, and legal people compliance I bundled together. So I listed some of the potential events or situations that a typical association can encounter and assigned a hypothetical association score from 1 to 5, where 1 is extremely unlikely to happen and 5 is very likely to happen. Some of these risks are enterprise level risks and should be shared with the board along with your mitigation plans, which we'll talk about next. So here's a sample plan for addressing a couple of those risks that I just enumerated, which you should create these for any risk that you score a 4 or a 5. You need to be able to protect your data and trust the output. close the shadow AI gap, govern AI use, and comply with all applicable laws, agreements, and standards. So a few things that your policy or governance system could address include asking your system to cite its sources. Many tools, including Claude, can return the source patches, along with the answer, sometimes with a link or a page reference. Turn that on and treat an answer with no citation as unverified. Keeping the source library organized and dated. If AI is drawing from a pile of documents, you need to know which version it was used. Spot checking the citations. That kind of traceability only helps if someone actually opens the cited passage and the answer matches it. So those are a couple of the ways that you can regulate and manage the risk. Now there's a technical side as well that your IT team likely already has in place a lot of these things, especially if you use SharePoint or a shared file server. But there's a technical governance layer, and this is where you can remove some of the burden from the individual employee reading a lengthy policy and put that into your governance system. So that looks like managed identity and access. So everyone signing in through the organization's account to the AI tool so access can be granted and reviewed and revoked. Making sure that there's a no training guarantee in your contract with your LLM vendor. Data loss prevention rules, likely a lot of you already have those in place as well. Rules that detect when sensitive content that you define as sensitive and can block, warn, or even log when someone tries to move it somewhere it shouldn't go. And then what Mark was talking about earlier with permissions and least privilege, the AI can only reach what the user can already reach, so tighten the underlying access if you need to. If someone shouldn't have access to those exam results, then you need to revoke that access, and that's something your IT team can do on a role-based version on an individual basis as well. Web off, internal only mode, that makes sure that the tool draws just on your governed sources and uploads, not just arbitrary web pages. And making sure that logging, retention, and auditing are in place so that if a record of what was asked was surfaced, you can review it. And agents throw a whole nother wrench into AI governance and policies. AI agents are intelligent systems that make decisions and plan multi-step actions based on content. They handle ambiguity, learn from patterns, and adapt to variable inputs. Most of us are starting to explore using them because they really can save a lot of time. They can take actions for us. And that's why we're creating so many of us are creating assistants and agents as well as prompt libraries. But these also have gaps that need to be addressed in policies and governance frameworks. So here are just a few things to consider when you're considering governing agents. Setting the boundaries, so making those decisions before you try building an agent of what the agent can do on its own and what it needs to give back to a person to do it. Controlling the reach, naming the tools and actions that each agent can touch and the ones that it cannot. Keeping the receipts, holding a full record of what the agent did so any action can be traced back later. And asking your vendors, does this tool keep a record of the actions the agents takes, not just the chats? And if this sounds overwhelming to you, even in the corporate world, Deloitte is reporting that only 20% of companies deploying agents have a mature model for governance. And as you saw in the previous slide, 40% of enterprises are demoting or decommissioning autonomous agents because of the governance gaps in them. This is not an easy question to answer. I did create a checklist that you can use as a starting point for documenting your agents, automations, assistants, and key prompts. And there's a QR code and a link at the end of the presentation to get access to that. And then lastly, on the technical governance side, is data governance as the foundation for AI governance. And when a business deploys enterprise AI, they usually don't just buy access to a model, right? They connect it to their own stuff, the shared drives, the emails, the document libraries, and the internal databases. Tools like Microsoft Copilot and Google's Gemini for Workspace work this way. Now, when a staff member asks, what did we decide about that 2025 dues increase? The AI doesn't get the answer from general knowledge. It goes and reads your organization's actual files and answers from those. That's the whole appeal. But there's the catch. AI is only as good as what it reads. So if you point a brilliant assistant at a messy filing cabinet and you get confident, well-written answers built on garbage. So clean data isn't a nice to have before deployment. It's the thing that decides whether the whole project helps or embarrasses you. And what does that mean? I hear this all the time from IT vendors. You need to have clean data. You need to have clean data. Here are 4 helpful guidelines about what the content is. Not having 3 versions of your member handbook sitting around. There needs to be one source of truth, not 5 copies of it. You can't have the same document exist in 4 folders that usually have small differences. AI can't tell which one is authoritative, and neither can staff. So deduplication matters. Everything should be labeled and organized. Metadata, sensible folder structure, and clear titles are how AI and people understand what a thing is. A file named, and I've seen this many times, and I've done it myself, a file named final v3 uses one tells a machine nothing. You need to be very specific with what the file is. And then lastly, the data your LLM has access to should be accurate and complete. If the underlying records are wrong, AI is going to faithfully repeat the error. It doesn't fact check your own data against reality, it trusts it.
Kathy, these are really good rules for just records retention in general, too.
Yes, I agree 100%. So we spent a lot of time on AI governance, and you should too. But the more you can protect your association's data, reputation, and other risks via a governance system, the less you need to rely on staff to remember the details, understand the rules, and rely on an AI policy. There are certain core components that should be addressed in your AI policy. And every governance control moves on. So AI core sections. So these are some core sections that you're going to want to cover in your policy. And I've enumerated out the 12 areas and the different questions that it settles for your team. So your AI policy should include these, and you should create the supplemental operating procedures and processes, AKA the governance system, for managing each one of these in a practical sense. So let's take a look at just a couple quick examples. So number 7 was human oversight. You can actually define tiered levels of scrutiny. The level of scrutiny for AI output that is a social media post is vastly different than the level of scrutiny you need for an AI chatbot on your website or agent or assistant. And your policy can, again, specify levels of scrutiny. Or number 5, member and speaker content. You're likely going to have to update your speaker agreement to specify how you plan to use AI tools and reaffirming who owns the intellectual property. And then number 9 is interesting, use of AI in meetings and access to the recording. At my last association, we started with a really restrictive policy stating that no bots were allowed in the meetings. But about 10 months later, the use of chatbot across our member base had grown so significantly, we walked that back and provided guidance for the use of recording bots, who and which meetings. There are too many details and nuances to a good policy to provide you with a sample that you can just copy and paste. But I did create a sample policy associations can customize for their own context, and an excerpt of that is available on my website as well. I've also provided some good links to solid frameworks like the NIST framework for creating your policy at the end of this presentation. And as Mark so ably indicated, there are a lot of legal concerns involved when you're using AI, and a lot of responsibilities and new laws popping up everywhere. So just be aware that your legal counsel may be needed to review your AI policies and governance framework. Basically, anything that you have to abide by and comply with, it doesn't go away just because you're using AI. It is part of your organization, and you can be held liable for its content. Okay, and then roll out. Now that you've got the basics of what goes into an AI policy and a governance system, of course, you've got to roll that out to your members and staff and board. So here are just a few things to remember about that. There are a number of communications that need to go out depending on your specific uses of AI. So for instance, if you're using a member-facing chatbot or agents that touch member data, you'll need to communicate that more to the members than simply using AI to draft emails or plans. Make sure that all staff know where to find a copy of your policy and governance procedures and train them on it at least annually. Record the training, of course, so that staff can have a refresher if it's needed or to onboard new hires. You can also, I've seen people do this. We did this at my last association. We pinned a Teams chat to the top of Teams that link to the policy. So you can do the same thing, put that on the cover, the homepage of your SharePoint site, Teams or Slack as a reminder of what that is. So the thought that we want to leave you with is that your AI policies and governance have to work together. The longer you're never put this in AI list, the more you're asking staff to police themselves. So every governance control that we talked about that you add moves that burden off the individual and onto the system, increasing safety, efficiency, and effectiveness. Here are some of the resources I mentioned, and I see that here are the resources that I mentioned, and I see that we've got several questions in the chat.
There's some copyright questions, Kath, which I think
Yep.
I'm going to try and answer those offline. I don't want to take our time here because we're really talking more about AI in this session. It looks like the first AI question, it says, for Shadow AI, can you please say more about what documentation needs to be employed for staff usage? And let me just say, the documentation has to, as Kathy was really trying to drill this in, has to be both focused on policy and governance together. Do you have thoughts on what kind of documentation, Kathy, related
So
to
yeah,
shadow?
you should be asking employees what AI tools that they're using to get any work done and have an open culture where you can discuss that and talk about why it's important to have all company work related business on enterprise tools that you are in an approved list that you have. I'm not sure the documentation is your AI policy and your governance procedures for staff usage. Shadow AI is just your team using AI on their own without using your model or approved tools.
Okay, the next question is, wouldn't the creator, educator of the chatbot be responsible? I think so there's different types of responsibility in that case regarding Air Canada. The chatbot is their agent. And I think in many cases where a chatbot is being used as a representative of an organization, the organization is going to be held responsible. Now, it could be the case that you're using a third-party vendor to handle the chatbot for you. So maybe there's some responsibility there also. But I'm not sure that an organization would be able to offload all of that responsibility. It could offload some liability through a contractual arrangement, but in terms of who's responsible to the consumer, the user of the chatbot, I think it could apply to everybody involved. The next question, what rights does an employer have in restricting AI tool usage? You have lots of rights. I think the employer has lots of rights. And that if they want to prohibit AI usage 100%, I think they're able to do that. The next question, what does this mean for AI note takers in board meetings or executive committee meetings? I've never been a fan of recording board meetings or executive committee meetings or other types of sensitive meetings with any kind of recording mechanism, whether it's just audio recording or it's an AI note taker, because it's a recording of everything. And sometimes you don't get the proper context of a conversation from a recording. And the problem with recordings, I was just talking to a group about this the other day. The problem with recordings is that it records everything, every single potential utterance by any participant in the meeting, whether intended or not. Right? And for somebody who wasn't a participant in the meeting to go back and look at that recording and try to understand that may be difficult. The other thing about recordings is that it could chill discussion. If people know that they're going to be on record with respect to any specific topic, they may not talk as freely as they want to. So those are a couple of the reasons that I'm not a big fan of recordings in general. Here, maybe Kathy, you can take this one. How are organizations enforcing their AI policies?
Sure. I've seen associations do a number of things. It depends on the severity of an incident. If something happens, if something happens and it affects a member or impacts the association's reputation or trust, you tend to have stronger sanctions, including warnings. But up to if confidential information was released, for instance, member lists or things like that, sometimes firing is on the table. You just need to talk with your HR team and understand what other ways are you enforcing your employee policy and mirror that with your AI policy. And then the question, Mark, did you have anything to add to that?
Yeah, I think it just goes back to your overall governance model, right? Just because they're AI related doesn't make them any less or more important than your other policies. Governance is about making sure that your policies are being utilized and complied with. And you really have to have a strong governance model in order to be able to do that.
Yep. And then the question, yes, you may share this presentation with your organization's AI committee. Feel free to do that. The slides and recording will be out within hopefully a couple hours, depending on how long Zoom takes to process it. Any comments about the dual cost of AI, once for the subscription and second with the organization's IP data entered into the service? That is definitely, I just read an article this morning. I wish I could remember where I read that, but there are definitely some moves by companies to build their own models using like Llama or Grok instead of relying on OpenAI or Anthropic. So I'm not sure what else to say about that. Mark, do you have any comments?
Yeah, I'm not sure if I totally understand the question about the dual cost. Certainly, you have to provide, you're going to have to spend for some type of use of AI or development of an AI platform for your organization. But with regards to a cost of the IP data that's going in, I don't know how you would capture that. And in general, again, I'm not a big fan of putting proprietary material into any model because the only thing that's going to protect you from widespread usage is the security measures that you have in place. And we know from the constant data breaches that happen on a daily basis that that's not really it's not really a good indicator of how safe something's going to be.
Yeah, and I think with the data that you put into it, the concern that I saw, at least in the one article I read, was about the model itself, OpenAI, getting information about your company's processes, proprietary or not. Like you're just saying, it's a good reason to keep that out of there, but they have a record of all the chats and all the feedback and corrections that you give to the chat. So they have a very detailed understanding of your business model, your customers or members. And the fear expressed in that particular article was somehow that they could use that information competitively against you with other products and services that they might create. So I think that was the concern.
Yeah, and I think that's a really good point because you could say, what's the difference between having a secure database where we have our member information and a generative AI platform where we're putting in the same kind of information. I think the point that you're making is, yeah, the member database just has these fields, whereas in the generative AI platform, you might be putting in strategy prompts, you might be putting in discussions where you're using it in a way that gives folks a lot more insight into how you do business versus just a bunch of member data fields. So that's something to think about.
Yeah. I think the next one is all you.
Yeah, aren't recordings of board meetings discoverable? And the answer is yes. Absolutely, they're discoverable. And that's one of the reasons why I'm not a big fan, because not only are they discoverable, but then you have every single utterance that's potentially made during the meeting that you would have to potentially try and explain. So it's not really, I think, it's not the risks related to a recording, I think, are much higher than the benefits that you may receive from a recording. Now, if you're absolutely intent on using a recording, then what I would suggest is that to use it simply to update the notes that you take. Once you've updated the notes, that you delete the recording, and that the recording only be accessible to those folks that are going to be updating notes and not to potentially everybody.
Okay, and then our last question is that we use an AI LLM for helps with reports and writing newsletters, but not entering member information. What problems could this cause, especially if you opt out of sharing your chats with the LLM itself? I'm not sure of any problems. If you're not entering any member information into it, you certainly don't have that risk or exposure. And if you're not sharing your chats with the LLM itself, that's also a good thing. You don't want your information training their model and becoming part of their knowledge base. Mark, is there anything?
Yeah, I think hallucinations, that's one thing that might be an issue. So you obviously you want to be verifying anything that the M is generating with respect to information about your organization, information that it could be pulling from public sources. You want to make sure you're verifying those kinds of things so that you're not misrepresenting yourselves or anybody in particular. And then you also want to be careful about whether you have any interest in owning these reports, claiming copyright in these reports and newsletters. Because if you're using a generative AI platform and really all you're doing is just entering a prompt, create an article based on this topic with this information from our organization, there's a significant chance that you're not going to be able to claim ownership, and that anybody can then go ahead and take that output that you've generated and use it for their own purpose.
Yeah, those are all really good points. We're almost at the top of the hour here. If there are any more questions, feel free to drop those into the Q&A function. Thank you all again for being here on this webinar. I hope that it provided some useful information and some practical takeaways for you. Do follow up with either Mark or me, and if we can provide any further help for you. And yeah, I'm looking to see if there's questions. Oh, we got some thank yous in there, so that's great. Thank you. Thank you for sharing that.
Yeah, and
All
I'm going
right.
to follow up on the copyright questions offline to the individuals that submitted those.
Wonderful. Okay. Thank you for doing that.
Thanks,
Okay.
everybody. Have a good rest of your day.
Thanks, everyone.